Just to, we had questions yesterday, and we kind of thought that it would be good to get you in here and we can get some clarity on that one issue. But real quickly, we now have, because we did some action last night, we've got a really pretty short voting list. So what I'd like to do is just go through here, knock that out. We'll take some questions from Ross, and then I think and then we have 1 o'clock hearings, okay? Everybody good with that? So with that said, let's just go right to the list. And Senator Carrozza, we're going to hold House Bill 178, okay? So we're going to take that off the list as a hold. And now let's just go down the list, and there's one bill on the second page. So Senate Bill 11, Stacy, let's just go through
Senate
this.
Bill 11, Public Financing Act, Fair Campaign Financing Fund Distribution. This departmental bill alters the earliest date on which distributions from the Fair Campaign Financing Fund may be made to candidates for governor and lieutenant governor participating in the gubernatorial public campaign financing program under the Public Financing Act. The bill moves the date from January 1 of the year of the election to July 1 of the year before the election. There is one amendment to this bill, which is found on page 3 of the packet. And essentially what this change does is it aligns the first report filed to the federal filing deadline. So it changes that report due currently on the 3rd Wednesday in January to the 4th Wednesday in January.
Any questions for Stacy on that piece of legislation or that amendment? I apologize.
Move the amendment.
Okay, Senator Simon Ayer moves the amendment. Second from Senator Harris. Discussion. All in favor of that amendment to Senate Bill 11, raise your hand. All opposed? Okay, we have the bill, Senate Bill 11, as amended before us. Any questions, motions? Senator Harris moves favorable. Is there a second? Second from Senator Brooks. Discussion. Okay, all in favor, Senate Bill 11, as amended, raise your hand. Anybody opposed? Okay, we have one dissent from Senator Gallion. Okay, that bill carries. Senate Bill 11 does carry. Senate Bill 24.
24, State Emergency Medical Services Board, Public Access Automated External Defibrillator Program revisions. This departmental bill alters the Public Access Automated External Defibrillator Program by 1, clarifying which entities are required to participate in the program, 2, exempting a law enforcement agency from obtaining a certificate for an AED that's just deployed in a patrol vehicle, 3, codifying the role of an AED coordinator and establishing specified requirements for the coordinator, and 4, repealing obsolete provisions related to regional councils and regional council AED committees. The bill also makes conforming and clarifying changes. There is one amendment offered by the chair on page 6 of your packet. The reprint begins on page 8. This amendment requires an entity that is a grocery store or restaurant to qualify for a certificate to register with the program and maintain the functionality of each AED in accordance with certain standards.
Any questions about that single amendment? Okay, is there a motion on that amendment? Senator Harris moves that amendment. Is there a second from Senator Brooks? All in favor of the amendment to Senate Bill 24, raise your hand. All opposed? Okay, that motion carries. Senate Bill 24, as amended, is in front of us. Is there a motion? Senator Harris moves the bill, Senate Bill 24, as amended. Is there a second from Senator Brooks? Discussion. All in favor of Senate Bill 24, as amended, raise your hand. All opposed? That motion carries. Okay, let's skip over Senator Kagan's bill. Okay, let's just bump over Senate 181. We'll come back to that. Let's go to Senate Bill 197. April.
Senate Bill 197, Land Use Comprehensive and General Plans, Alteration of Elements. This departmental bill from the Maryland Department of Planning modifies and reorganizes the elements that a local jurisdiction must include in a comprehensive plan so that the elements, 1, are consistent with planning principles established under Chapters 63 and 64 of 2025, and 2, apply consistently across all local jurisdictions. The bill also adds and modifies certain guidance and requirements applicable to the plans as a whole and to specific elements. There are amendments in your bill packet. So these begin on page 35 of the voting packet. And you can see the reprint starts on the next page. So these are being offered by the Department of Planning, or recommended by the Department of Planning. The first one, these are mostly in negotiation with some feedback that they had gotten from MACO, and then there are a few technical changes in these as well. So amendment number 1 strikes hospitals and places of worship from the list of facilities that may be included in the community facilities sub-element of the land element. And I would note that this list had been taken from current law regarding what is currently the community facilities element, but MACO and some other stakeholders argued that the continued inclusion of these particular facilities was inappropriate. Amendment number 2 requires the place element to plan new or revitalized public spaces for community engagement rather than to plan, design, and program such spaces. This was another MACO recommendation. Amendment number 3 is corrective. It simply corrects the reference to the land element. The current draft of the bill just says land use element, but that was the old name of the element. Number 4 is also corrective. It updates the list of reports that must inform the housing element of a non-charter county or municipality's comprehensive plan to be consistent with the listed reports for charter and code counties. And finally, number 5 provides for the bill's prospective application and makes clear that it does not apply to comprehensive planning processes begun or completed before the bill's effective date. That was another MACO recommendation.
Okay, questions for April on these amendments to Senate Bill 197? Okay, any motions? Senator Harris moves the amendments. Is there a second? Second from Senator Brooks. Any discussion about the amendments that April just described? Yes, we have a question from Senator Hester.
Just one question. If, like, hypothetically, if somebody was just starting their planning process in, like, July, and they wanted to use this, could they? Or does it say that they may not?
They're starting it in July, and the bill's effective date is October.
I mean, can we give the county some, I guess I'm going after, like, could we give the county some flexibility?
I would not interpret this bill as prohibiting them from doing so.
Okay, thank you. That was my question.
Okay, Senator Carozza.
Thank you. A question for April. The amendments, it sounded like were worked through with both MACO and the NAIOP. Do you know if they were?
My understanding is that NAIOP actually, in conversation with the Department of Planning, removed their opposition and in fact had no opposition on the House side. So.
Is that the same for the Maryland Building Industry Association?
Yes, so some of that was based off of a little bit of a misunderstanding of what the bill was intended to do, and they had follow-up conversations with the Department of Planning.
So the amendments that planning offered were worked through with NAIOP and MACO?
They were worked through with MACO. Again, I think NAIOP understanding, once they understood what the bill is doing, no longer opposes the bill, is my understanding.
Thank you.
Okay, additional questions for April on the amendments? Okay, we had a motion and a second. Okay, any further discussion? All in favor of the amendments as described by April, raise your hand. All opposed, the amendments carry. Senate Bill 197 as amended is in front of us. Is there a motion? Okay, Senator Harris moves the bill as amended. Senator Brooks second. Okay, all in favor of Senate Bill 197 as amended, raise your hand. All opposed, that motion carries. Senate Bill 241, Stacy from Senator Augustine.
Senate Bill 241, Election Law, Individuals Released from State Correctional Facilities, Automatic Restoration of Voter Registration. This bill requires the Department of Public Safety and Correctional Services to electronically transmit to the State Board of Elections on a weekly basis information on individuals released from incarceration at a state correctional facility in the immediately preceding week in order for SBE to then restore the voter registration of such individuals who were previously registered to vote in the state before being incarcerated and whose new residential addresses are in the state. Notification must also be sent to an individual notifying them of their voter registration, their eligibility to vote, and how to decline registration or update their address. There are amendments in your voter packet beginning on page 43 with the reprint available on page 45. The amendment requires that on or before January 1, 2028, this state board and the Department of Public Safety and Correctional Services jointly develop and implement procedures and an electronic submission process for the restoration of voter registration for individuals released from incarceration in a state correctional facility. The amendment describes the information that must be provided to SBE from the Department of Corrections each month instead of weekly, requires a prompt versus automatic registration of voter registration of covered individuals, and notwithstanding the Public Information Act, prohibits disclosure of voter registration agency through which the formerly incarcerated individual was registered to vote.
Okay, can't recall, did you say there amendments? No.
That was the amendments I just
You just described, I apologize.
Sorry.
Okay.
Did I not explain that? I
Question,
apologize.
yeah, questions for Stacy on that amendment, that set of amendments or amendment?
Mr. Chair,
Yes, Senator Watson.
I'd like to be amended as a co-sponsor to this bill.
Anybody else want to go on the bill as a co-sponsor? Okay, I'm looking at Senator Harris, Senator Brooks, in addition to Senator Watson. Anybody else? Okay. Okay, you want to make a motion on the sponsorship amendment, Senator Watson? Okay, second. Okay, all in favor of adding those three members of this committee as sponsors, raise your hand. All opposed? Okay, we've done that. Now let's go back to the amendments that Stacy described. Questions on that one? Senator Harris moves those amendments. A second from Senator Brooks. Questions on that packet of amendments? We're going to go to Senator Gallion.
So the one, it changed it from a week to a month?
So the reporting would be every month they would receive a report on all of the individuals who were formerly incarcerated or have now been released from a facility.
So the thought being on that is a week was it was just too much, like
Yes.
you needed. So is a month the right amount, or should it be 2 or 3 months? I mean, are we still sure that that's not too big a burden on them to try to get all that done every month?
No, I mean, they were negotiated out between SBE and the sponsor.
Okay, all right, thanks.
Okay, additional questions for Stacy? Yes, Senator Simonaro.
Are there anybody in Maryland that are permanently banned from voting? Like fraud or anything like that, that they've been?
Honest with you about that, but if you know the answer, I don't know the answer.
I'm pretty sure that those who have been convicted of election-related crimes.
I don't know.
I'm pretty sure I know that one, there may be others.
Are they exempt from this bill?
This only applies to felons who have been incarcerated in prison. So I don't think, I would check on that. Let me see.
My point is, we don't want to be putting them back on the rolls automatically.
No, if I'm mistaken, the bill only talks about, let's see here, 241.
Why don't we do, let's go to the other bills, and then we can come back, and maybe Stacy will have an answer, and then we can make a decision about a hold. So let's go to Senator Brooks's bill, and meanwhile, Stacy, you could, see if you could research that. Okay, Senator Brooks, Senate Bill 431. Oh,
Chair, I want to hold that. We're waiting on an amendment
okay,
from the Farm Bureau.
okay, fair enough. So we're going to hold Senate Bill 431 from the sponsor, from Senator Brooks. And there's one bill on the back page, Senate Bill 581 from Senator Jennings. Devin?
Senate Bill 581, Department of Information Technology, Statewide Information Technology Master Plan, reporting. This bill requires the Secretary of Information Technology to post the Statewide Information Technology Master Plan publicly on the Department of Information Technology's website within 6 months after the date the governor is inaugurated in the governor's first term. If the Secretary is unable to meet the deadline, the Secretary must notify the governor in writing and specified committees of the General Assembly within 10 days after the missed deadline. The notice must include an explanation of why the plan is delayed and provide a date for its publication, not to exceed 3 months after the initial deadline. There are amendments offered by Senator Jennings in your packet beginning on page 51 with a reprint following. The amendments change the 6 months for posting the plan to 1 year after the governor is inaugurated and clarifies that the plan is submitted in each gubernatorial term rather than the first gubernatorial term. Finally, the amendments require the department to brief the General Assembly on the plan each year.
Okay, is that the extent of the amendments?
That is the extent of the amendment.
Questions on the Jennings amendments? Any questions? Okay, Senator Gallion moves the Jennings amendments. Is there a second? Senator Carrozza, is that okay? Any questions on the Jennings amendments? Okay, all in favor of the Jennings amendments, raise your hand. All opposed, amendments carry. We now have Senate Bill 581 as amended in front of us. Any motions? Senator Gallion moves the bill as amended. Senator Harris seconds. Senate Bill 581 is in front of us. All in favor, Senate Bill 581 as amended, raise your hand. All opposed, that motion carries unanimously. Let's go to the back to the front page. Any clarity on, okay, so in response to Senator Simonero's question, Stacy?
So three types of individuals in the law have been described as not qualified to register to vote. Those are those convicted of a felony and currently serving a court-ordered sentence of imprisonment for that conviction, is under guardianship for mental disability, and a court of competent jurisdiction has specifically found by clear and convincing evidence that the individual cannot communicate with or without accommodations a desire to participate in the voting process, or an individual who's been convicted of buying or selling votes. This bill specifically only applies to those individuals convicted of a felony and currently serving that sentence. That's the only people that fall under this bill.
Okay, and the people buying and selling, that's a misdemeanor?
I don't know what the penalty is, but I'll look that up.
I mean, okay.
But they're just not qualified to register at all. So if you were convicted of that, then you would not, even if you were released from prison, you would still not be allowed to register to vote under these provisions because you're just not qualified.
Okay, and that says it in the bill that you have to be qualified.
It says,
I thought it said you just had to previously be registered before you went to.
right, I mean, you would be previously registered even if you had been convicted of buying or selling votes. You could have been, but you're still not qualified. You have to still be qualified to register vote even if you fall under the provisions of this bill. For example, if you gave up your citizenship, you came here, you committed a crime, you do all those things, and you came back, you would still not be qualified to register to vote. You still have to qualify.
Okay, I thought the way the bill was worded was if you were a convicted felon and you were registered prior to that and you came out, this would say you automatically get registered to vote.
But it's not automatic anymore.
Okay.
They send the information, and they still have to verify the information.
Gotcha.
That's why they changed it from shall to promptly.
Gotcha. Thank you.
Okay, so we had adopted the sponsorship amendments. Did we adopt these amendments? Do you recall, Stacy, do we adopt the
We did not adopt these yet.
Okay, so we have these amendments in front of us. Is there a motion on these amendments The sponsor amendments, Senator Harris. Okay, second from Senator Watson. Okay, all in favor of the amendments, these amendments, raise your hand. All opposed, those amendments carry. So now we have in front of us, Senator Augustine, Senate Bill 241 as amended. Is there discussion, motions? Okay, Senator Harris moves the bill. Is there a second from Senator Watson, the other co-sponsor of this bill? Okay, Senate Bill 241 as amended. Do you need a roll call, or do you want to take just a hand vote? Okay, all in favor, raise your hand. Okay, all opposed? Okay, the 3 no votes, Gallion, Carozza, Simon Air. So that bill carries 8-3. Now, I'm sorry, 7-3 with 1 absentee. Okay, let's go to Senator Kagan. We have 2 more bills left on this list. Senate Bill 132. Stacy, this is an emergency bill. Stacy?
Senate Bill 132, election law, affiliating with a party and voting unaffiliated voters. This emergency bill authorizes an unaffiliated voter to apply to change the voter's existing voter registration to affiliate with a political party during early voting before a primary election. If an election judge at the early voting center determines that the voter resides in the county, the voter may vote and have counted a provisional ballot for the political party. There is one amendment offered by Senator Kagan. You can find that on page 16 of the packet and the reprint on page 19. This amendment extends the authorization to change party affiliation to an unaffiliated voter who appears at a precinct polling place on Election Day during a primary election and changes the effective date of the bill to January 1, 2027, therefore striking the emergency bill provisions.
Okay, Senator Kagan, you want to add anything to this piece of legislation beyond what Stacy described?
Thank you, Stacy. So again, this is not an emergency bill. Clarifying that Maryland would still be closed primaries. It would allow unaffiliated voters to become Democrats or Republicans during early voting or on Election Day. There are almost 1 million Marylanders who are unaffiliated, and 42 of the 47 districts, Senate districts, were decided in the primary. And so these folks don't have a voice in our races or in other races. We sent this to the floor a couple years ago. This is slightly different, and this is in collaboration with the House and the version that they've got. With this, with these amendments, Jared said he can do it with existing resources. There is no fiscal note. Happy to take any questions if there are any.
Okay, take questions. Let's go, Senator Harris. You had the light up, and then we'll go Senator Gallion. Senator Harris?
Yeah, so I understand the bill. The part that I just don't understand is when we say that they don't have that this bill helps them have a voice, but technically they do have a voice. They just decided not to utilize that voice, because they can affiliate any other time throughout the year prior, but we're saying that we're going to give them all the way up until the very last second to affiliate with a party.
Thank you for the question, Senator. We pay a lot of attention to details an election year or year-round, all the years. The average voter doesn't. And so it has to be more than 3 weeks before Election Day, and yet the mailings, the TV ads, the radio ads and stuff come last minute, so people aren't paying attention yet. When I say that their voice isn't that heard, if you were unaffiliated today and went to vote, you'd be handed a ballot for Board of Ed.
Right.
That's it. Not even judges, even though they're nonpartisan. And so these are people we want to have engaged in democracy, because a lot of people, if they move here from another state that has open primaries, they didn't know they had to pick, or they moved here from another country where if they register with the wrong party, that their family could be literally in danger, or if they're young and they're just kind of a pox on both their houses. I agree with this from this party and this from this party. They don't realize that that means they can't vote in a presidential, gubernatorial, congressional, or state senate primary, which is the race that matters in most races.
Let's just take questions. We can discuss the actual bill, but just for now, questions on the amendment that takes this out of the emergency status. Senator Gallion, just on the bill.
On the amendment or on the bill?
Well, it'd be both. We could
Do you
just.
wanna- do you wanna-
Okay, here, why don't we do this?
So,
Is
the
this about the amendment or the bill?
Yeah, starting with the amendment.
Okay, on the amendment, questions on the amendment?
Thank you, Mr. Chair. So if I understand it, originally as it came in, it was just if someone was showing up to early vote, they could change. But with the amendment now, it'll even allow it on Election Day.
Correct. So someone who just moved here can show up. As you know, Maryland has Election Day registration. So it creates equity so that whether you are a lifelong Marylander or you're someone who just moved here from another state, you can vote, you can register and vote a full party ballot.
Okay. So just to speak on the bill.
Why don't we hold off on the bill? Can we just talk about the
Sure.
amendment? We still have to take the
That's
amendment
all I had on the
up.
amendment. I just wanted to clarify.
Okay, just on the amendment, further questions on the amendment? Okay, do you want to move that amendment?
Move the amendment.
Okay, Senator Kagan moves that amendment. Is there a second on the amendment from Senator Hester? Okay, let's take because I don't know where everybody is. We'll take a roll call here on the amendment that is before us. Lemuria, this is just on the amendment, the
Okay.
Kagan amendment.
All right, Senator
Roll call.
Kagan?
Aye.
Senator Kagan, yes. Senator Hester?
Yes.
Senator Hester, yes. Senator Gallion? No. Senator Gallion, no. Senator Watson? Yes. Senator Watson, yes. Senator Attar? Yes. Senator Attar, yes. Senator Harris?
Yes.
Senator Harris, yes. Senator Brooks?
Yes.
Senator Brooks, yes. Senator Carozza?
No.
Senator Carozza, no. Senator Simon Ayer, I'm sorry.
No problem. No.
Senator Fowler?
Okay, yes, that amendment carries 7-3. Can we now have the Bill 132 as amended in front of us? Before we get a discussion on the merits of the bill, is there a motion to put it on the table for discussion?
Move favorable as amended.
Okay, Senator Kagan moves the bill as amended. Is there a second from Senator Hester? Okay, now we have the bill in front of us. Questions, discussion? Senator Gallion speaking to the bill as amended.
With all due respect on this, I just think, if you're unaffiliated, most of these people they're smart enough to know that, hey, I'm not going to be able to vote on most of these, in these primaries. So, if you really want to vote in a primary for a bunch of candidates, these people should file as a Republican or as a Democrat. That's just my thoughts on this. So, unfortunately, I'm not in favor of the bill, but that's kind of where I am on it. Thank you.
Okay, but actually, this unaffiliated, because it's still a closed primary, right? So you have to move from unaffiliated to Democrat or Republican, and then you can vote in the primary. You can't stay unaffiliated. This is not an open primary. It's still a closed primary.
Right, but this allows you to do that all the way up to Election Day.
Okay, that part's true.
Which, and as you're trying to reach voters as a candidate, and you have these, it makes it much more difficult to reach people that you're actually trying to target in a primary. So that's concerning.
Okay, okay, go on.
Contact them in a primary because they wouldn't be able to vote for you.
They could show up on Election Day and switch from independent or unaffiliated to whatever party and then vote. So there's no way if you're running in a primary race that you could know that person is going to do that. So you can, through mail or whatever, you can kind of target that if you know the person's affiliation a little bit out, but you no longer can put your mailings out. Well, you could, if you wanted to send all these, a ton of independents, but, my campaign account's probably not as big as others. So anyhow, I just I'm not comfortable with that, but it's okay. We can.
I might suggest, Senator Gallion, that you also wouldn't be reaching out and contacting or mailing to someone who recently moved into the state or moved into the county or moved into your district, and they need to re-register. So someone who just moved from my district to yours wouldn't be registered, and they'd be able, with this bill, to change their address, change their party, and vote provisionally. So they can start getting engaged in your district.
I think
District
those
35.
numbers would be pretty small, honestly. I don't think I have to. I don't know how many people are moving in 2 weeks before, and that, so I don't think that's.
Okay, Senator Harris.
Mr. Chair, I'm trying to get there. So can we hold this bill. And so can we hold
fine.
the bill?
I'll defer to the sponsor on that.
That's fine, Senator Harris.
Okay, so we're going to hold Senate Bill 132 for now. Okay, with the last bill's 181, which also could take some discussion. Ross Goldstein, before we take that up, because this may take some time, Ross, why don't you come up here, because we had, this back and forth about Senate Bill 56, and I want to be respectful of your time, because I know you might have a meeting over at Ways and Means. So, okay, how we left it, I don't remember exactly how we left it. We weren't quite sure about, there were some amendments floating around. We had Amendment Senator Reedy and back and forth. So I'll open up for questions. Senator Hester, just if you had to, just to get the conversation going while Ross is here, what are kind of the key issues from where you sit? Because you're the floor leader on the bill, and it's still special orders sitting out on the floor here. So just ask what
Thank
you
you,
can ask.
Mr. Chair, and thank you for being here today, Mr. Director Goldstein. As the floor leader, I've accumulated more questions than I know what to do with about this bill, so they're not necessarily my questions. But one of them is about the kind of open nature of the bill. I think people are on board with the current grant. The reason for doing this for the current grant. The concern is that where does this end? Like, how many third-party data brokers get access to our kids' data? So, and that was one of the points of the amendment that Senator Reedy shared with me was that, could or should we be notified, 30 days before, 30 days after one of these agreements is signed? Because what happens, while this administration and you in particular may be very conscientious, what happens in out years?
Great. Well, thank you for the question. Again, Ross Goldstein, from the Executive Director of the Maryland Longitudinal Data System Center. Thank you for working on this bill and these thoughtful questions. So the intention is only to do this project with the Coleridge Initiative. When we were working on the bill, at one point we did draft it so that it just said the Coleridge Initiative, but the governing board felt that was maybe too limiting, because what if the Coleridge Initiative, for whatever reason, goes out of business or doesn't continue to do this work, or there's a better system that's brought online, that we think that would be a better approach. So they felt it was a better approach to rely on their oversight and expertise about this, but there is no intention to have this be open-ended and I don't see why we would want to share this data with multiple data centers at one time. Really, the idea here is to work with one at a time to work on these types of projects.
So I think if the bill was drafted that way, all the questions would go away. Our concern is that, we don't know what happens in the future, and it's kind of opening the doors to many different data center, agreements. I don't know if you wanted to share the previous draft with us, but that is one of the big concerns is how many third-party agreements will there be, and how do we know? And so that's one line of questioning.
Just put all the issues out there for Mr. Goldstein, and then we can make a decision on how to proceed here, okay?
Okay. I think the second question is about kind of what criteria the governing board will use to determine whether a proposed project is appropriate, and what exact data elements may be shared under the bill, including disability-related, discipline, juvenile services, child welfare indicators. So it's both like who is approving the data and what data is being shared. And once again, there's this project, but then there's all the other projects.
Correct. So again, and we face this question right now all the time. We have a lot of, we're a small staff, and so in order to really get the value from this data center, we do allow external researchers to come in and use our data. And so we have this entire process set up where they come, they apply they write down their project proposal, we review it internally, we make some changes, we work with them to make sure that it meets our needs, and then it goes to, we have a research and policy advisory board, which is made up of key stakeholders and representatives of our board members. They review the project, they have an opportunity to discuss how it might impact their agency, maybe talk about data, which data they think are appropriate for this researcher to use. And then those decisions are made. If there's any controversy or there's something that's new or novel about it, it will go to the governing board for their final review and approval. So we face these types of questions all the time. I think it would be the same sort of process where we would, because this is all, again, remains project-based. So right now the project is with Washington, D.C. and Virginia. And and we will go to the governing board as we sort of finalize this project with Washington and Virginia and say, this is the project we're proposing to work on with this multi-state data sharing. We're thinking it's going to be something like the Career Preparation Expansion Act report that we file annually with the General Assembly, which looks at high school student outcomes 5 years after graduating high school. And so, what are their workforce outcomes? And we disaggregate that by whether they went to college, whether they have a degree within those 5-year periods. So there's a lot of information embedded in that report. So it would be that type of thing. We would go back to the governing boards and then say, this is the type of data that we want to share. These are the type of questions that we're going to be asking. This would have gone through our review process. This would be discussed with our Research and Policy Advisory Board. So we have processes in place already that we would utilize to make decisions about this.
And so could you comment on who is on the advisory board and then who actually will be reviewing the data sharing agreement, the contracts, the privacy assessments before they get signed off on?
Sure. So just very quickly, the governing board. So I report to a 15-member governing board. The governing board includes the principals of each of the agencies that we receive data from. So that's the Secretary of Higher Education, the Superintendent of Schools, Secretary of Labor, Juvenile Services, Human Services. We also have a representative from, the Chancellor of USM is on the governing board, the President of Morgan State is on the governing board, the President of MICUA, the Executive Director of MAC. And then there's about 5 at-large members, one of whom has to represent PSAM, the Public School Superintendents Association. We have a expert in large data systems and security on the board. And so I think that's the majority of the board. I know I'm missing a couple members, but so the Research and Policy Advisory Board is a representative of each of the principals. So the agencies, that are providing the data, they have people who are on the board, on this Research and Policy Advisory Board. We also have a number of researchers on the board to advise us about the research-related issues. And so that's who makes out this board. So we have, and in terms of, the governing board a few years ago established a subcommittee on security, cybersecurity, and that meets periodically. And that includes our expert on large data systems and security. It includes my CIO and then the CIO, and if they have a CISSO of each of the partner agencies. And it also includes the DO-IT security officer. So
it sounds like there's really good expertise on the board and the cybersecurity committee, but like who is actually going to review the contracts, the audits, or the privacy assessments before it gets signed off? Because you mentioned that you have a very small staff.
Right. Well, certainly. I'm going to review it. The Attorney General's office is going to review it. I think this on any of the security issues, we will take that to our cybersecurity subcommittee. So I do think we have a lot of opportunity to review this, with our various experts.
Anybody else can join in. I just got lots of questions here.
Well, I think you've got, get the questions out here.
Okay. So I don't know if you answered the question about the data elements that may be shared under the bill, including any disability-related, discipline, juvenile services, or child welfare indicators. And then, kind of along that same line, what measures, like once we share them, who owns that data? And how do we ensure that the kind of the research findings, or the data, doesn't come back to hurt us in some way?
Sure. So again, the way the bill is written, the governing board will make the final determination about data elements being sent under this agreement. And then, so they will review that, and they will review that annually. So at any time, they can adjust it or remove certain data elements. The Coleridge Initiative, and again, that's, who we plan to go forward with, their system is partitioned and only shared with approved users. We get to determine who the approved users are for our project in concert with Virginia and Washington, D.C. We retain control over the data, and so when the project is over, there's a process by which we will send the Coleridge a termination agreement, and they are required to destroy our data once the project is over, and they get audited on that as well. So part of their FedRAMP certification requires ongoing audits. One of the things that are audited is if they receive a data destruction request, that data does get properly destroyed and removed.
So you can confirm that the data cannot be shared for non-research purposes, such as eligibility determinations or compliance actions?
Correct.
Okay. And the questions you're answering right now, though, are because you have, or in the drafting process of a data sharing agreement with the Coleridge Institute, correct?
Correct, although I think these are the types of things that we would make sure are in any data sharing agreement. But again, yes, I would agree with you that a lot of what we're thinking about and how we're planning this is based on what we know how Coleridge operates.
And just to confirm, the legislation prohibits secondary sharing by third-party platforms?
So in other words, you're asking, could the third party redisclose our data?
Or share it, yes, to share it in any form whatsoever.
That's correct. Again, so they can only allow access to our data for people that we've approved to have access to our data. We make the determination about who gets to work with our data.
Okay, and then what happens if this third-party data broker or a subsequent one has a data breach? What recourse does the state have?
That would be spelled out in the data sharing agreement. There's usually some form of, liability insurance that they would be required to have as part of these agreements.
So, so they would have some kind of liability insurance. So like if all of a sudden Maryland's kids' data is hacked and it winds up everywhere, then the Coleridge Research Organization's liability agreement is going to cover any harm that would come to the state.
That's correct. And I'll just remind you that and it talks about this in the legislation, that one of the goals is that we share as little personally identifiable information as possible. And so there's other techniques that they use, including hashing of, sensitive information, so that you're not actually providing that information, you're providing a hashed value of it, which adds another layer of security.
So, I think, fundamentally, or speaking for me personally, colleagues, I feel like this is a great third-party agreement, right, with this specific research institution. And I think the question that I still have in my mind is, does this body want to give, authority to the MLDS to do this for any third data research center going forward? I think it does specify that it has to be for multi-state use or something.
It does. It specifies that now in the legislation.
So, and then the question on the floor with this amendment is, if we do give them this, they say they're not going to do it very often, but do we want to be notified? Is it our committee? Would it make more sense for it to be the presiding officers? I think we're kind of back to where we started with this notification and just whether we trust them, given everything that we've heard, which we might, to do this going forward with other third-party data brokers. But that is a committee decision, not mine.
Okay, while we have Mr. Goldstein here, any questions from any other members of the committee for Mr. Goldstein? And I see Senator Harris has a question.
Yeah, so back to the actual, the amendment piece. So one of the questions that we had was, we said within 30 days after enter into in the written data. The question was, should it be 30 days before entering into the written data? And is 30 days enough, right? And then what do we do with it after we receive it?
I'm sorry, the 30-day is a notification to,
Oh, so the amendment is within 30 days after entering into a written data sharing agreement with the third-party center in accordance with subsection C, 2 of this section, the center shall notify the Senate EEE Committee and the House Ways and Means Committee in accordance of the state government article that the center has entered into a written agreement.
I see.
And so should it be 30 days after, 30 days before? Should it be 2 months? What's the significance of 30 days after, and then what do we do with it?
Yeah, I'm not sure what the significance is, except that you're notified that this has happened. So I would really leave that up to the committee's discretion. I don't necessarily have an opinion on that.
Okay. Any additional questions for Mr. Goldstein? Okay. Well, thanks for coming in. I think this is one where we're not going to take any action. We got some issues on the table. We're going to probably have to discuss it amongst ourselves. So let's continue this dialogue and, I think continue until maybe Tuesday at some point. So thank you again for coming in. I really appreciate it. Okay, so that brings us to the last bill on the voting list, Senate Bill 181. We have a couple members absent now, so this is relevant to vote counts and all the rest, but that's it. Okay, Senate Bill 181. Why don't you just describe the bill, the amendments that are on the table. Let's at least get that conversation going, and then we'll see where we are, okay?
All right. Senate Bill 181, Hunting Lead and Lead-Based Ammunition Phase Out. This bill requires the Department of Natural Resources to phase in a requirement that non-lead ammunition be used for hunting of all game species by July 1st, 2029, with a phase-in period beginning July 1st, 2027. Subject to a requirement that the department authorize the use of lead ammunition for muzzle loaders, handguns, rifles, and shotguns if non-lead ammunition is not commercially available. There are amendments in your voting packet, as well as a separate one that I just passed around. The first one is on page 28. This is an amendment from the bill sponsor, Senator Lewis Young. It updates the preamble language and substitutes the word firearm for the word weapon in the provision related to the commercial availability of non-lead ammunition. It's a non-substantive amendment. It just conforms it to the House cross file. On page 33, there's an amendment being offered by Senator Hester. This amendment authorizes individuals hunting under the authority of a deer management permit to use lead ammunition until June 30th, 2031. So the general deadline would be, for everybody else, July 1st, 2029. Deer management permits are issued to landowners, particularly farmers, orchard owners, and in some cases, forestry practitioners who have documented deer damage on their property. It allows them to hunt deer on their property for the purpose of controlling those deer in accordance with the permit. And this would give them until June 30th, 2031 to continue using lead ammunition. Finally, I just passed around an amendment from Senator Gallion that would essentially turn the bill into a study. And so it would require the department by July 1st of 2027 to conduct a comprehensive study on the use of lead and non-lead ammunition for hunting all game species in the state, and then set out the parameters of what should be included in that study.
Okay. What I'm thinking is, well, first of all, since we have two amendments and we have members missing, this could be kind of a tight sort of vote, to be candid with you. So, Senator Hester, just to speak to your amendment, and then I'll give the same courtesy, Senator Gallion, and then I think we're just going to, I'd rather take a vote of sorts on amendments and bill when we've got at least 10 of our 11 members here rather than, just winging it. And so, but if you don't mind, would you want to just speak briefly to your thinking on your amendment, and the same thing with Senator Gallion, and then I think we'll stop and then we'll break until bill hearings, and then we're going to start at 1:15 on the bill hearings, give you a little break, okay?
Just in speaking to my amendment, I was approached by both the Howard County Farm Bureau, Montgomery County Farm Bureau, and the State Farm Bureau, just saying that this was going to be a financial hardship on the farmers in particular because they shoot, more deer under their crop damage permits than anybody else. And they've stacked up on potentially 5 or 6 years worth of ammunition. And so, I think that ultimately this is the way that we want to go, but that these folks in particular, needed a little bit more runway to use up what they had. And it was going to be more of an expense on them because they don't do it recreationally. They do it to protect their crops. And so that is the purpose of my amendment.
Okay, and Senator Gallion, why don't you speak to your amendment and just get it out on the table so we know what we're dealing with when we come back on Tuesday and may take this over?
Sure. So this, to me, the amendment is more than just turn into a study bill. It's, I think, a better approach to this whole issue, quite frankly. If you look at what other states have done, no other state has really jumped in with both feet like this bill would do, quite frankly, as far as a ban. I mean, California is the one that kind of we can look at and say, okay, they have the full statewide outright ban, but their situation was a lot different. They have an issue with condors out there, and we've heard about what they call the gut pile, stuff like that. And I think that was really the impetus for their bill. And the last time I checked, we don't have any condors in Maryland, so it does make us a little different. So I had a chance of driving home last night to talk with a friend of mine who's a hunter. He's not a farmer, but he's a hunter. And I would support Senator Hester's amendment as well, but, quite frankly, you have the crop damage permits that would address, but in these certain areas, even the recreational hunters killing deer is helping farmers because it's less deer traffic. I mean, I know I had 30-some acres of corn in last year, and the deer did some damage on that. So whether it's under one of those crop damage permits or a recreational hunter killing the deer to thin them out, it's all helpful to me. This hunter last night talked about how, the price of beef right now has made it so he, fills his freezer with venison, with deer meat. He's what you would call technically a recreational hunter. So, the issues with the bill as a whole that I think that are addressed in that study, there's uncertain availability and practicality of the non-lead ammunition. I had a question last night from my friend when I was talking. With a rifle, there's some of these, they're lead in the middle, but they're cased in copper. So I'm assuming that's part of the ban because there's lead in the middle of it, even though it's cased with copper. The other thing is how these hunters shoot the animals. They're not shooting them in the guts. They're trying to hit them in the shoulder and the heart for that kill. They're not just shooting in the stomach where this animal would be. So that's not even accurate with how hunters work and try to kill these animals. It does create an economic burden for these hunters because it is more expensive. I think there's enforcement and regulatory challenges for DNR that's created with this, without the amendment I'm proposing. And honestly, there's a lot of potential unintended consequences on hunting heritage and participation. And I know, so there's some animal rights folks there that have a different view on this. I take more of the view on the looking at the overall picture and what damage is done through to our crops and hurting our agriculture, our farmers' bottom lines with having more deer pressure all the time. And also, we had a bill in here a couple years ago that dealt with animals getting hit on the highways. And that's mostly deer that you hear about. I mean, we're hearing all the time about people running into bears and foxes and stuff like that. It's deer, okay? So the less of them that get thinned out, more cars are going to get hit. So this, I think this is a common sense amendment that would honestly get me in a position I could vote for this as, with this amendment, because I think it takes a good hard look at the whole thing. It looks at the study assesses the available scientific evidence regarding impacts of lead ammo on those wildlife populations. including the scavengers and other species. You know, we hear about the eagles and the gut piles all the time. This addresses that. It's an evaluation of the availability, cost comparisons for the non-lead. So that would be in there. Also, last couple things.
Just last couple things.
Yep, the economic impact that I mentioned on the hunters, including increased costs. It looks at that. It also does a review of existing federal and state approaches to lead ammo, and it would make recommendations for future policy changes.
Okay, why don't
So
we-
this, just in closing,
Okay.
this amendment would be a comprehensive look before we jump in with both feet on what I think is very bad policy. And this is our way of making sure we bring good policy out of this committee through this amendment.
Okay. So Senator Harris, why don't you have the final word, because we're not voting on the bill. I'm going to hold it, but if you want to
Yeah,
make one final comment,
Yeah,
then we
so
can.
being at this, Senator Gallin's amendment changes to a study, does that impact the fiscal note?
Yeah, it would be difficult to anticipate. I mean, we could ask the department what it would be, but it probably would add some fiscal note.
Okay, so we have the Hester amendment on the table. We have a Gallion amendment on the table. Anything before I put a hold on this and we'll continue the conversation? No, I think I'd like to let this percolate. Yes, Senator Hester, any final thought?
I actually was up kind of late last night reading through a lot of these studies and talking to one of my farmers in particular, and he's like, well, listen, like if we're poisoning like the animals, like I really don't want to do this. So I sent him a couple of the studies and he read them, and he's like, and he texted me back this morning. He's like, Senator, did you read to the end of the article? And I'm like, well, which one? So then I got to the bottom of it, and he said, well, at the end of the article about like the eagles, he says that the lead's coming from the fish that they eat, And so I'm like, I don't know. There's a lot of information here, and I was just curious if maybe the counselor, the advocates, could like really say, like, we know lead is bad, and we know, but is it definitely coming from the lead ammunition, and is that definitely like hurting the animals, and especially when we donate it to the food banks. Like, I don't want to be hurting people at the food banks, but there's a lot of studies that I've been given, and they all like have a piece of it, but they don't all like kind of.
Okay, I think we're going to hold this bill. We're going to start bill hearings at 1:15, so you have a 20-minute break to relax and come back here at 1:15, and we have a relatively light schedule, and then you guys will be done for the week. And okay, so see you back here at 1:15, okay?